So I promised that we would come back and talk about what side we'd argue. Sometimes you got to argue both sides. Just like in our APRN practice, there are no areas of black and white sometimes in instances. Same thing. And sometimes, or most times, we don't get to choose our patients unless they don't do what we ask of them repeatedly and we document ad nauseum, and then maybe we can let them go with a certified letter and all these other things and policy procedures to back us up. So same thing here. We know the basics. We're coming back just to refresh you here. We're going to see how would we defend her, and so we're going to have a lot of interaction here this next hour or two. Okay, the BON licensing hearing. Now, what if you're reported? What if you were Pat? Oh, God forbid, you know. But let's say if you were, and let's say they did take away your prescriptive authority number and they went crazy on it and they wrote a gang of people, a ring, which are known here in Houston and other metropolitan areas to use people's scripts without them even knowing it. We've had several now that have used the scripts of nurse practitioners before the whole thing with controlled twos and calling them in, pretending they were the nurse practitioner, pretending they were the doctor, calling them into various pharmacies and then never using them and selling them. And as things have become harder to procure, it has really become a very hard area of the law. I'll give you an example before we get into this. I have a DA friend of mine, and we had this discussion. My question to him was, listen, I have a healthcare client. They know for a fact that at least 3 of their seniors are getting Lord tabs, and then they're turning around and selling them for $10 each. They get a bottle of 120. They're supplementing their income $1,000 to $1,200 a month, and they're selling them in the neighborhood with glee. You know, my Lord tab came in. I'm about to make some money, and you have 75-year-old drug dealers. Okay, so shades of gray here. Big sigh at the end of the line. I won't mention the DA's name. He knows who he is. And said, Joe, how does it look if I'm prosecuting 80-year-olds for selling Lord tab? I go, almost as bad as when you prosecute them for doing 8-liners and gambling, you know? I said, but he said, from a policy standpoint, it looks bad. So maybe the worst of the bad apples, they come and warn them, talk to them. DPS, which was handling it, doesn't want to get involved. DEA is stretched thin. Raiding 85-year-olds' houses is a little bit difficult. Everybody on the ground, well, you know, I can't. I'm gonna, you know how long it's going to take for me to get up. So these are issues that have become a national problem. It's not just West Virginia. You know, you've seen documentaries here and overdoses in Ohio and things like that have become national prominence. It's these other sticky issues. Yes, sir.
This is a little bit off going back, but can you walk through what is the process, or if an investigation or a complaint is received on the provider, when are we notified that an investigation is opened up, if it were to happen?
Let me try to understand your question. Your question is, if you are under investigation, when would you know?
Right. You said there's these dozen people with their stacks of paper doing the legwork.
Say a complaint goes through the mill. It usually takes probably a month to 3 months to process. You get a letter certified, you get a letter regular, and say, you know, information has been obtained that you have been violating this Practice Act. Please be advised that you have 20 days to answer. Well, without a lawyer, you got 20 days to answer from the date it's postmarked. So that's really more like 15 days. And so the first thing, if you get a lawyer, the lawyer files a response and says, I just got hired. What the nurse doesn't know and what they don't tell you, because they don't have to tell you. They should be able to tell you. I tell them it's not really fair. But if you ever get such a letter, you ask for more time, number one, to get a lawyer. Number two, you ask for what's called discovery. You ask for the documents they have, a CD. They usually have medical records and things. Their HIPAA doesn't apply to governmental entities. They can get anything they want. The federal agents, HIPAA, if you look at HIPAA statute carefully, DEA can get what they want. They come in and with a subpoena, where's your HIPAA consent? We don't need one. We're the government. Give me all your records. So that's what happens. And then the complaint gets generated. It's a very good question. Then either you lawyer up, you should. If you try to answer it yourselves, which many people don't have the money for a lawyer. You know, it can cost anywhere from $3,500 to $10,000. So if you don't have insurance. So you file your own answer. I didn't do it. I swear, you know, but this, you know. So now you're committed. You wrote a handwritten answer or a typed answer. You've made admissions. You've said things, and you can't go back. You've made things, and then they'll say, okay, and then they'll say they're investigating. Then you're talking to the board investigator yourself, trying to justify your position. The beauty of having a lawyer is you can always blame it on the lawyer. If the lawyer says something wrong, you say, well, I didn't say that, the lawyer did. And then the lawyer can say, I misspoke. Let me rephrase. That's why you have a lawyer.
So lawyer
right?
up first.
Yeah. You know, well, I didn't understand the client that well, you know, but people will answer their own complaint and they don't know the law and they don't know the traps. So they're just trying to be honest and they'll confess. And so there's ways of, like I said, the hatchet guy, if he had answered his own thing, they would have lynched him, you know. I mean, he would have answered his own thing. I did the hatchet, I did all this. But by the time I got him, he had already taken a lie detector test. So we couldn't go back on that. So I had to think of an argument. You have to do something with the impossible puzzle. Now that he's taken and he admitted to all these, you know, immoral and illegal acts, how do I try to convince the board that he's not an imminent harm? So that's what we're kind of looking at. What if you were reported to the BON? Let's put ourselves in Pat's position. The complaint and a SOAH hearing. You can ask for a hearing to fight for your suspended license. On Pat's case, they immediately suspended. Imminent harm. You know, we can ask for a hearing or we can waive that couple of week notice. And we can go just immediately to SOAH. What's SOAH? State Office of Administrative Hearings. They are separate from the board. They are a separate entity from the board. They're down the street from the board in the Capitol. And what you do is you have like 1, 2, or 3 judges. You don't get a jury trial. You go in front of them and it's a trial, kind of like a European trial in front of judges. You don't get a jury and you put on your evidence. And a lot of the rules are a little bit different than the rules of evidence in state court. But a lot are very similar. It's about 80-90% similar. The informal conference is the first step. Say you want to try to work it out before you go to SOAH. They hold the carrot and the stick with you. We'll give you a lesser punishment if you go to informal, tell us what you did, and here's what we're offering. Sometimes you don't even have to go to informal. Half the time they'll say, okay, your lawyer filed an answer on your behalf. We're offering remedial education, no suspension, but you're going to have to take a jurisprudence class. You're going to have to take this. You're going to have to take that. Okay? What they don't tell you is that if I take any kind of deal, you're going on the National Practitioner Data Bank. And people say, well, what significance does that have? You have a record now. Whether you committed a crime or not, you have a record. CMS looks at it, all the healthcare institutions, your insurance carrier looks at it, and they look at the data bank. It could prevent you from getting hired. I've got RNs, just, you know, garden variety RNs, that they've stayed at the same facility because they didn't know this, but they try to get on with travelers and recruiters, and they sound great. Oh, come on over. They fill out the paperwork, and they don't get the job. Every time they don't get the job. They don't know why. And they come to me and I'll say, you probably got reported. You ever been in trouble with the board? Yeah, like years ago. And I said, well, you're on the data bank. And so if they send you somewhere, the corporate people and the corporate lawyers go, why take a chance? She's been reported, he's been reported. And that's the thing. Even with a slap on the wrist, you can be reported to the data bank. How long does that stay on there? Pretty much perpetual. So I try to fight for a dismissal. On this case with Ms. Smith, it's going to be very hard to get a dismissal, okay? I'll tell you that. But we're going to try to find a way to keep her from getting revoked. Now, you people that are on the board side, think of a way to revoke her, okay? So there's nothing informal about an informal conference. If they say, okay, we think it's serious enough, you need to come up to Austin. I drive up to Austin. Somebody from Lubbock, I get clients from all over. They'll come in from Lubbock, Amarillo, wherever, you know, Brownsville, Houston. We meet up and we go in there, and there's usually a panel between 5 and 10 people. Sometimes the executive director's there. Usually a lawyer for the board, first, second, or third in command is there. They're calling the shots and they're making the recommendation. And Mr. Diggs is there, who is the chief investigator. Very nice man. And he's there with his laptop. He's got everything open. We sit at the end of the table. They're on the table. Sometimes they have us in a big auditorium, and then all these student nurses can watch. It's kind of like feeding the Christians to the lions, right? And so we go in there, and they're like, why do they have to be here? I go, because it's a public hearing. They have the right to be here. And they was like, this is so embarrassing. I said, I know, but we have to come in there and face the music. And so it's very nerve-wracking. Sometimes you just go in there and it's just them. It depends on the day. It depends if they want to send a message and scare all the student nurses. They'll invite a bunch of student nurses. Everybody's invited to come so that people can sit in. Half the time the student nurses sit in. And so let's say you can't solve it, or they made a recommendation was, well, suspension. Well, in Ms. Smith's case, in Pat's case, they're going to want a revocation of everything. Okay, so we had our hearing. Let's go back on a suspended license. I went on the hearing. Let's assume that I went to that for the first month after she got suspended. We went up there. She's not an imminent danger. She's a great nurse, et cetera, et cetera. They said, no, denied. We're going to keep her suspended. Then I'll say, okay, well, what about a formal conference? Nah, not on this. Political. Right now, pill mill and accusations are like that. You can forget informal conference. They tell me, those days are gone. We're not going to mediate anything. We want revocation or nothing. So what choice do I have but to go to SOAH? Okay, State Office of Administrative Hearing is going to trial. Informal conference is a mediation, pretty much. If we look at our example of civil and criminal, civil cases, that would be like mediating it. SOAH is going to trial. They call it a hearing, it's a trial. So I have my exhibits, they have to give me their expert. You're going to see expert opinions in a minute, a sample of one. They give me these discs, like, you know, like on her case, they'd probably give me 7,000 scripts plus the medical records. So we're going through literally a couple of terabytes of information. You know, I don't know. Probably 10 banker's boxes, maybe about 200 gigs. But I mean, there's a lot of info. I mean, and we're pouring through, goes through about a month. I've got to meet with my client. I have to go through every script with my client. That takes a day to sit there and go, did you give this script? No. Did you give this script? Okay, let's take a break. You know, did you do this script? No, I didn't write any of these. They're lying. Okay, but when did you report? I didn't know they were doing this. Okay, so that's our defense. Didn't know. Okay, and then I'll say, obviously, we're going to have to get some sort of expert, a pharmacist, a doctor, to refute and say this happens. Here's our problem. Bunch of people want to be an expert for the board. Why? Because they wear the white hat. How many people want to be an expert for a plaintiff that's suing? How many people want to be an expert for somebody accused of being a pill mill? They don't want to be an expert. Why? They get targeted. They're afraid of it. They're afraid to speak out and say, you know, the Lord tab's not that bad, you know. Okay, all right, let's go look at you. And, I'm not saying they'll do that, but, you know, you're pretty much on the spotlight. That's the expert against us. So people fear that retaliation. So it's very hard to find an expert. Most of the time, you're not going to get an expert. So what do I have to do? You know, You got to use you don't have a sword and you're fighting a guy with a sword. You got to catch their sword and stick them with their own sword. You know, that's what you have to do. You have to turn their expert and make him your expert by discrediting them, humiliating them, twisting their words without being ornery. And that's an art. What if our APRN says she's innocent and will not take a 5-year revocation? State Office of Administrative Hearing. People ask me all the time, what if we lose at State Office of Administrative Hearing? I say, we appeal it. Where do we appeal it? District Court. We go to Travis County. We do it de novo, which is we started all over from scratch. Meanwhile, you're still not working. So here's the carrot and the stick. They say, okay, here's the deal. We'll revoke her for 3 years as an RN, permanently as an APRN, but at least she'll have a hope of working. By the time you go through this, Joe, she's not going to be able, bless you, she's not going to be able to work anyway, and 3 years have gone by. So what is the difference? And I'll go, the difference is my client says she's innocent and doesn't want to take that. She wants to fight it. You have to respect what the client wants, and you may win, or you may get a better deal as you prepare for trial. Another rule as a lawyer is to reach a peace, you have to prepare for war. Okay? You always have to prepare every case like it's going to trial, because they're not going to respect you if you're like, please give me a break. You see these guys on the courthouse steps trying to settle a case. Come on, I need this. My client, you don't know, I'm going to catch a grievance. You know, just give me probation. You know, that nickel and diming the cases, right? And it's basically selling your client down the river. If your client doesn't want to do it, then you say, here's the risk, here are the benefits, just like if we were an MP. Here are the risks of not going and doing a mammogram. Here are the benefits. Here are the risks of not, doing this surgery now. Here are the benefits, And so you tell them, you have to educate them. If we go to SOAH, there's a possibility you'll never be a nurse again if you lose. But you may be able to get a better deal, or we may be able to prove your innocence. But I'll say, in a case like this with 7,000 counts, they only use 10 charts. Chances are, and they use the 10 most powerful, if they catch you on one chart doing something bad, they're going to hammer you. So, that's where we're stuck on. So something like this, this is called, what's the style of the case? Enter SOAH. State Office of Administrative. It has a docket number, which I made up. Here's the petitioner, and we're using a different one. I'm a good APRN, right here. State Office of Administrative. The curly Q's, that's who you're going against. Here's where you're going, and the BON is the petitioner. They're seeking to revoke you, okay? And you're the respondent. You're the one that's responding to the charges. So that's what the paperwork, top of the paperwork, that's called the style of the case. Sample proposal for decision if our APRN gets hammered. This is what a proposal for decision called a PFD is. That means if we went to SOAH and if our poor APRN got hammered, they would do something like this. There's a summary of what they're going to do. The staff or the board, the staff is the attorneys for the board, seek to revoke the nursing license of the respondent because she allegedly violated the standards of nursing practice by continually prescribing controlled substances in a non-therapeutic manner. They love to say that. That's how they hammer you. You gave it to an 80-year-old like you gave it to a 250-pound 30-year-old. After considering the evidence and the applicable law, the ALJ, Administrative Law Judge, concludes that the staff met its burden of proof by a preponderance of the evidence. See, and here's where, remember what I talked about? Burden of proof in a criminal case? You got to go all the way, almost score the touchdown. 99.9%, On a preponderance, you tip the scales. So the administrative law judge only has to say, there's more evidence, more likely than not, that she was a pill mill, and concludes that it met its burden. The ALJ recommends the board revoke the respondent's license and that the staff be awarded costs of the case. Not only is she getting hammered with getting revoked, but she has to pay for the attorney fees and the costs of it. So I have to tell my client, if we go and you lose, you got to pay for their attorneys, you got to pay for the trial, you got to pay for the transcripts and costs, and then adding insult to injury, you're revoked. So a lot of the time, if you're prepared to fight it, which we are, the allegation, the staff's formal charge document, these are the allegations, right? They identify only a single charge, asserting there's no chance, there is hope, don't give up, right? Asserting that between December 16th and February 15th, while practicing as an MP and owner of the MP Care Clinic in Anywhere, Texas, respondent's practice fell below the minimum standard of care because she repeatedly prescribed dangerous cocktails of drugs to patients without regard to the therapeutic benefit. There's that word again. Without an individual assessment of each patient and without developing an appropriate treatment plan for each. More specifically, the respondent allegedly wrote, and I'm using this different one, this is an actual one, 9,309 prescriptions for the cocktail drug of hydrocodone, SOAH, and Xanax, often in the max, also known as the Holy Trinity, because you feel like you've hit heaven when you're on hydrocodone, SOAH, and Xanax. The respondent was able to do this because she operated a pain management clinic and had prescriptive authority in her role as a licensed nurse, specifically as an APRN. The collaborating physician signed the Lord Tab portion of the cocktail. She did the rest. Okay? So these are very serious allegations, right? Pretty scary, huh?
Yeah.
Right? And, well, they come to me and say, do something. You're the lawyer, right?
Now, if you are being paid for by medical insurance malpractice coverage, it would seem to me that if there's a risk of having to pay the costs of, if you lose, you pay the costs of the whole case, that it seems like the insurance company would be pressuring to settle.
Well,
Because they don't want to be exposed to the risk of paying court costs and all that.
well, what happens, it's a very good question for the record there. He's asking, wouldn't the insurance company that's paying for the nurse want or encourage settlement at this juncture? Not necessarily. Why? Because they're capped. They pay 25 grand. Whether I pay court costs or whether she pays them, and I use all the money to pay me and I don't use them to pay the expert, and all my bills ran up and we don't have experts, and I paid and used some of the money to get records and do all this stuff. That's why I don't order the original records. I get discs. Why? Discs are $11. Records are $800. Right? Okay, so you find ways to pinch pennies. Even if I could get an expert, they'd want $10,000 to testify, and we still have to have money left over to pay staff. I have another lawyer come in with me to work by my side. I have my legal assistant I've got to pay to work on this case. So you're having to manage the money, and they say, here's the money. That's all we're going to pay. So they're like, 25 grand is a drop in the bucket for an insurance company, because look at the risk pool. Only 3% are probably going to maybe 1% of nurses being investigated or less are APRN. So their odds are, all we're going to do is keep collecting policies. And even if we do have to pay out, the max we pay out is 25 grand. They're more worried on medical malpractice, because then their exposure could be millions if it's an economic wage earner that they treated badly. Then they're encouraging settlement and things like that. But with this one, there's a cap, so they're just going to pay it. Generally, the cap is $25,000, and most cases, even with the SOAH, I make it work. I make it work and give a good defense for that amount, and just make it work. Now, that's not counting federal, criminal. Yes, ma'am.
I'm so sorry. I missed the first conference, first workshop this
Sure.
morning. But I want to know, as far as you being covered by your employer's insurance, is it recommended that you have your own insurance policy on top of that so you can potentially cover something like this?
It could, because generally they cover med mal. Some of those policies that your employer has and people find out do not cover professional liability insurance as far as administrative hearings, or cover the price of a deposition. Sometimes unless you're the target of the suit in those insurance policies, you won't be covered. So for an RN, fortunately for them, they can buy insurance for $200 a year. We got to pay. Somebody asked this morning an excellent question. How much do we pay? Let's say anywhere from $1,500 to about $5,000. If it's OB, maybe more. But we get our own policy and make sure the policy has administrative, and it also has, if case you're sued, that they pay for lost wages, and you get an attorney to go with you up to like $5,000 for just for the depositions, just to have your deposition taken. So you have to look carefully at the terms and the policies. The BON language, the challenge to fight is the staff asserts the respondent should be disciplined for violating numerous provisions. Specifically, and that 217.11 that we talked about, and we'll get into detail in a minute down below, that 217 is huge. 11, 12, behavior unbecoming, committing violations, engaging in, and here's where the catch-all, unprofessional and dishonorable conduct. That's how they get to try to get your RN and LVN taken away. They'll say, if you acted like that as an APRN at the top of the food chain, you don't deserve to keep your LVN and RN because you're a danger altogether. You've probably been doing this all along and finally got caught now that you had prescriptive authority. Okay? That's how they come across. And I go against some excellent attorneys. They're true believers. I mean, they think the nurse is, that, you know, if they brought back the Salem witch trials, they'd be right up there. You know, they're true believers. They're very professional what they do, and you know, like I respect them because they're not making a ton of money, but they believe in what they're doing. But at the same time, sometimes they can be pretty unfair. You know, under the Nurse Practice Act, the board is authorized to take disciplinary action against a nurse for numerous reasons. We talked about that, the professional conduct. Based on the board's opinion, this is another one that they catch you on, you're likely to deceive, defraud, or injure a patient or the public. That's how they hammer your LVN and your RN. Because they say, where there's smoke, there's fire. If you do it with your APRN, you certainly can't be trusted with an LVN and RN. And that's how I have to fight and say, and I've won to keep their LVN RN, but their APRN on a case like this, it has to go away. If I get it back, they'll never get their DEA back. That's probably the best outcome. Rare cases, and I think I've got like one pending. I might be able to get their DEA back, but look at what they charged them with. And you know what? A lot of this is unjust because if it was truly correct that a ring stole their DEA number, it's like identity theft. That's one of our, hint, that's one of our defenses, identity theft. When you think it's impossible, well, we have to think the impossible and make it work. That's why we get paid as lawyers. Failed to care adequately for a patient or conform to the minimum standard. Now, let's take in our example, we look at the records that yes, she had a record for each patient. She weighed them, she talked to them, she talked about non-medical and therapeutic remedies other than medication. That's documented. She did the pain scale, she did PQRST, she did stuff on each individual patient. They still will come back and say, not good enough, it wasn't individualized enough. When they're after them, they're after them. Okay? So these, and you don't, these are another, your mind goes numb, don't worry about it. I'll put these up, but these occupational safety codes coincide with that unprofessional conduct. Occupational code mirrors the administrative code. 217 is the big one. That's all you have to remember is 301, 217. You can find all sorts of treasure trove in there. I can save you a bunch of time, but just remember 217, 11 and 12, 217.11, 12, and 301 of the occupational code. Or if you don't want to take a Benadryl to go to sleep, read it. I've done it. What do some of these codes mean? Here are examples. Like I promised, 217.11, carelessly failing, repeatedly failing, or exhibiting an inability to perform vocational, registered, or APN in conformity with standards of minimal accepted nursing practice. That's so broad. In other words, like we were talking about, it's almost like when I argue this, I'd say it without saying it because I don't want to make them mad. They're making the rules up as they go along because it's general. One person can do the same thing as another and they like the person's attitude and the other person comes in there swinging, they'll treat that different person differently. It's like when a policeman stops somebody and they treat one person differently and another. Maybe it's because of color or maybe it's because of attitude. It depends, you know. Carelessly or repeatedly failing to conform to generally accepted nursing standards in applicable practice settings. Very broad and general. So they can throw this big dragnet and catch you. So why insurance for the APRN is so important? 25 is the usual. That was his question. Excellent. Cost includes experts, attorney's fees, transcripts, meals, accommodations. Here's the money. Do what you will with it. Spend it wisely because that's all you're getting. And then anything over that, the nurse has to pay. I try to stay within the confines of that. Sometimes we have to go over a little bit because it does get expensive. And 25 is that's a budget. Defense experts are needed and you will see why. And if you don't have a defense expert, like I said, when you don't have a sword, use their sword against them or try. Dr. Jay-Z, the BON's expert, weighs in. So they have an expert to hammer. Remember, we were talking about that. Wait a minute, where does this BON investigator that's not an RN, not even an APRN or LVN, where do they get off judging us? Well, what they do is they go run to Dr. Jay-Z. And Dr. Jay-Z will find out the qualifications are that she's a licensed RN, an APRN, and earned a PhD in public policy and administration. Very impressive. And has been licensed as a nurse for 16 years. Dr. Z testified in 2 parts during the hearing. First, I did a she, he there, I'm sorry. First, he offered testimony that identified the applicable rules defining the scope. You're going to go, this is all lawyer talk, so I'm going to break it down because it's so, lawyerly. Defining the scope and standard of practice for RNs and APRNs. So she said, what's the standard? Discuss how they limited and defined a licensee's practice. Pretty much broke it down. Second, Dr. Jay-Z testified as to the nature of the respondent's alleged violations and the sanction that staff determined was appropriate for respondent's conduct. In particular, Dr. Z testified to the following opinions. Respondent violated, and then they start going in specifics. Failing to properly demonstrate she consulted with a delegating physician before writing the scripts for controlled substances beyond 90 days. This is why the 3-month window is so important. After giving controlled substances, even the 3s, the 4s, if you're not evaluating in 90 days or pain management or trying to wean off, they're starting to look at it heavy. You can't keep them on the pain meds now with the policies the way they are, with the politics the way it is. You can't keep them on in infinity unless you send them to what? Pain management. We're not set up unless you're running a pain management clinic and you're an FMP and then you have a 78-year-old doctor. They're red flags, and retiring anesthesiologist that's already been sanctioned. Red flags. Respondent is subject to discipline by the board for failing to properly assess the patients and document. We say, no, here are the medical records. She assessed each one individually, took their weight, height, PQRST. They went ahead and saw each patient. They counseled each patient. They talked about pain, what they do to relieve the pain. They did a full physical assessment. So we're having to build our ammo, okay, for the administrative judge to listen to. Because we're usually going with one administrative judge decides the person's fate, not a jury. Respondent failed under 221.13, the core standards for APRNs by failing to know and conform to Rule 222, my eyes are blurring, for prescriptive authority of APRNs. Failure to be aware of and follow the requirement for the physician consult for prescriptions beyond 90 days. The 90-day window, remember that. If you're handling meds, even just the SOMA or the Xanax separately, remember, 90 days is pretty much red flagging, and by failing to know and conform to the Nurse Practice Act. by failing to promote a safe environment for clients, by putting them at risk through continued prescription of controlled substance without adequate assessments. That's broad. What is adequate assessment? We've done the PQRST, we've done all this stuff. We have experts out there saying, that's not enough, you need to do even more. Well, all of a sudden, that was fine for 20 years, but now the last 3, when Bill Clinton came out, I said, that's it, it's over, you know. Bill says it's bad, you know. He said, you know, people are getting hooked on Lortab. I think it's bad, you know. I do a pretty good Bill, but, you know, and then he says, it's an epidemic. And if Bill says it's an epidemic, you know, he just wants 2 more terms, you know, by failing to know and conform to the nurse practice. So I knew it was a watershed moment when they started doing that, and by putting them at risk through their continued prescription of controlled substances without adequate assessment. So when we look at that, more conservative care, what does that mean? PT, yoga, meditation. Well, guess what? In San Diego, Texas, I don't think a lot of people do yoga. You know, they're just like, give me my Lord tabs, or I'm going to go to another page. So they've been on them 10, 15 years. And now you're just going to cut them off with nothing? They'll go to somebody else. They're going to find it some way, or they'll go to something worse, illicit use or heroin. And that's what's happening around the country. So are they doing the right thing by cutting these people off or just weaning them? I don't know. But this is what we're dealing with right now. And by prescribing medications without due regard for their effects on the patient. So they're trying to say that they just wrote the same script over and over again. We've got the MA that's trying to save his neck and saying, yeah, whatever you guys said, it's true. And the doctor says, I have cancer, don't let me die in prison. Yeah, she did it like that. So you got 2 witnesses, you know. There's an old saying in the federal court, if 2 people say you did it, you did it. You know, they'll say if you got 2 people saying, you know, and you say you didn't, you know, it's a swearing contest. Dr. Jay-Z, I mean, it never ends with Dr. Jay-Z, pointed out that this one, this is the one I was telling you about, 217.12, carelessly failing, repeatedly failing, or exhibiting inability to perform her nursing duties in conformity with the minimum standards of care. And by carelessly repeating and failing to conform to generally accepted nursing standards. More of general language. To wit, specifically by prescribing medication without therapeutic benefit. Okay, as I said, 20 years we said it was okay, now it's without therapeutic benefit. Respondent violated the Occupation Code 301 by failing to care adequately for a patient or to conform to minimal standards. You see how they overlap each other. They hit you with the Texas Occupation Code, they hit you with the Administrative Code, and then they try to decapitate you with 301 4S2B, committing unprofessional or dishonorable conduct. What does that mean? To defraud or deceive or injure. Our argument is she didn't do that. She was running a clinic, she was documenting everything, and she was seeing people. They're going to come back with, come on, people coming in from East Texas, driving 90 miles to see her, and they're coming in from Beaumont to Houston and looking for their fix. That's what they're saying. There's 20 pain management clinics all on the corridor, and you're stopping over here at this one at an MP run, and there's like anesthesiologists that have all these practices. Why come over here? A lot of people say everybody else refused me, didn't want to treat me, and those are good refuting things. You get letters from patients that say they treated me, they made me feel special, individualized. When I tell people your case is under fire, bring me letters from patients and we redact their name. But we leave their last name or whatever. HIPAA really doesn't apply, but I don't like to put their whole name and address and everything, so I kind of redact it. And I show them the letters. Look, the patients believed that they were getting treated. That's another arrow that we use to defend, okay? And we say that they were treated. We look at and we'll get the medical records. We'll go through all the records and say, you didn't look at the other ones that say she did treat the 80-year-old differently than the 250-pounder. She did do this. You're using all these general things to say that. Let me see. Where are we on time? Did an hour already go by? Well, let's take a break. Because, man, Dr. Jay-Z has a lot to talk about. And this is the summary. Sometimes their expert reports are like 20 pages. So we'll find a way to minimize Dr. Jay-Z.